Right here, I'll go test, and we'll green.
School roads, justice. So it should be over here now. Can you like blow them up? Like,
Oh, shit.
no one's gonna believe us now.
Oh,
Yeah, play it. Yeah, play it. You're still. Yeah, wanna record. Yeah.
what? Test, and we'll green.
School roads, justice. That's me. It should be over here now.
Okay, we can go on record.
Please rise. Today is the 16th day of July in the year 2025. The Frisco Municipal Court is now in session with the Honorable Judge Ron Carlson presiding.
Please be seated. For many of you, this is the first time in court, or at least the first time in this court. Court procedures require that I start each case by reviewing the original ticket with you. That is, to make sure you're advised of the nature of the charge against you. I just read the name of the charge. If you wish, I can read the longer statutory version, but generally most people know what speeding is, or what trespass is, or what shoplifting is. Then I'm required to tell you the maximum possible penalty. And again, that's a possible penalty, but it's required to tell you the downside. Then third, I'm required to ask you some questions that establish you've read and understood your legal rights. If you haven't read them, please do so at this time, and I can assist you. I will ask you if you have any questions, and we can go through that as necessary. Then we can get to how to handle your case, and I know many, in fact, most of you probably have talked to our prosecutor and have an agreement, but I must take those preliminary steps before we can get to your agreement. And then there's a few questions I'm required to ask regarding that. It's not just a matter of signing off on it. There's a few questions we have to go through to make sure it's a free and voluntary plea. So please be patient. All this takes time, but it is designed to protect your legal rights and to make sure you have a clear understanding of what we're doing here. The first case I have is it Annette Visser? Could you come to the podium, ma'am? Good evening.
Good evening, Your Honor.
Ma'am, you were summoned to court to answer allegations you supposedly violated Model Traffic Code Section 1402, which is careless driving. Do you understand the charge?
I understand.
The maximum penalty for that is 4 points on your driving record and a fine as high as $2,650. Do you understand the maximum penalty?
I do.
You were provided the written advisement of legal rights. Did you get a chance to read and review those? Do you have any questions?
No.
Do you feel you understand them?
Yes.
Do you know what a trial is? And you understand you have a right to an attorney? I have paperwork that says instead of a trial, we wish to agree with the prosecutor to plead guilty to a 2-point defective vehicle with restitution reserved and the monetary penalty left up to the court. Is that what you wish to do?
Yes.
You understand that by pleading guilty pursuant to this agreement, you are giving up all the rights listed in the right sheet, which means there will be no trial, there'll be no witnesses. The prosecutor will not have to prove you guilty beyond a reasonable doubt. You are giving up your presumption of innocence and right to an attorney.
Correct. Yes.
Did anybody threaten you to get you to plead guilty?
No.
Did anybody promise you anything that's not been said in court?
No.
Is this your free and voluntary plea?
Yes, it is.
Are you under the influence of anything that affects your ability to make a decision?
No.
Now we've covered the required questions. How do you plead to 2-point defective vehicle?
Guilty.
Court accepts your plea, find to be freely, voluntarily, and knowingly made. At this point, you have the opportunity to, but you're not required to make a statement either about what happened or what you think the penalty should be, but you also have the right to just remain silent. So is there anything you'd like to tell me?
No, except I mean, I guess one light at the end of the light in this is that the man who is the victim in this case is doing all right. So that's really paramount to me. So.
Well, I appreciate that attitude. I'm just reading the police report, which I don't do ahead of time in case there's a trial. I don't want to be biased by one side. So I read these as people appear. Okay. And I'm not seeing right offhand a driving record. Is it in here? Have you had any tickets in the last 5 years?
No.
Okay. Court will cut the scheduled fine in half. 200 is a $100 fine. However, there's a $25 surcharge imposed by counsel and a $30 court cost. So the total would be $155. Are you able to pay that today?
Yes.
Would you please step aside and talk to my court clerk? Daniel Quinn. Mr. Quinn, good evening.
Evening, sir.
Mr. Quinn, you were summoned to court to answer allegations you supposedly violated Model Traffic Code Section 1101, speeding. Specifically, there are different categories, and you're alleged to have violated the category of 20 to 39 miles an hour over the posted limit. Do you understand that charge?
Yes, sir.
The maximum penalty is a 6-point violation on your driving record, a fine as high as $2,650. And if more than 25 over, can be up to 10 days in jail. Do you understand the possible penalty?
Yes, sir.
You were provided the written advisement of legal rights. Did you have a chance to read and review those rights?
Yes.
Do you have any questions about those rights?
No, sir.
Do you feel you understand them?
Yes, sir.
Do you know what a trial is?
Yes.
You understand you have a right to an attorney?
Yeah.
I have paperwork that says instead of a trial, you wish to enter into a plea to a 3-point special hazard speeding. Is that what you wish to do?
Yes, sir.
You understand by pleading guilty to that charge, you're giving up all the rights in the right sheet, which means there'll be no trial, no witnesses. The prosecutor won't have to prove you guilty beyond a reasonable doubt. You are giving up the presumption of innocence and right to an attorney.
Yes.
Did anybody threaten you to get you to plead guilty?
No, sir.
Anybody promise you anything not said here in court?
No, sir.
Is this your free and voluntary plea?
Yes.
Are you under the influence of anything that affects your ability to make a decision?
No, sir.
Now we've covered that. How do you plead to 3-point speeding?
Guilty.
Court accepts your plea, find me freely, voluntarily, and knowingly made. You're entitled to make a statement and welcome to, but not required to. Is there anything you want to tell me?
I was just unaware of the change in the speed limit as I entered into the town, and I'm a veteran with a clean driving record, so would appreciate any leniency that you could share.
Yeah, I note the clean driving record, so I'm going to spare you the speech I had to give a half dozen times in Silverthorne this morning about, for whatever reason, I am seeing a rash of 6-point speeding. And I think you may be atypical of that, being not from here. Unfortunately, too many of them are local people who seem to have gotten a heavy foot in their recent vintage. And I've been warning all of them, if I see people a second time on a 6-point speeding, I will give jail time. I'll just mention that so you're aware of where I'm coming from on these. I don't expect to ever see you again.
Understood. Yes, sir.
Okay. You're going to take a driving class. Can you get that done in 30 days or do you need 60 days?
I should be able to do it in 30 days.
All right. So that part I will note on here is by August 20th. That's our next court date. Or appear on that date if you haven't got done, or contact my clerk for an extension to September 17th if something comes up. As far as the penalty in dollars, I will make that $150 fine. And the surcharge and court costs make that $205. Can you pay that today?
Yes, sir.
Please see my court clerk. I did. I got tired of battling with your pens and brought my own. Christine Duarte. Oh, I'm sorry, I'm reading middle names here. Rebecca Christine Duarte, sorry about that. Good evening.
Sir?
Ma'am, you were summoned to court to answer allegations that you violated Model Traffic Code Section 1101, speeding, in this case, a category of 10 to 19 miles an hour over the posted limit. Do you understand the charge? That is maximum penalty is a 4-point violation on your driving record and a fine as high as $2,650. Do you understand the possible penalty?
Yes, sir.
You were provided the written advisement of legal rights. Did you get a chance to read that? Do you have any questions?
No, sir.
Feel you understand it? Know what a trial is?
Yes.
Understand you have a right to an attorney? I have paperwork that says you want to plead to a 2-point defective vehicle. Is that correct? You understand you give up all the rights listed in the right sheet, meaning no trial, no witnesses. The prosecutor doesn't have to prove you guilty beyond a reasonable doubt. You are giving up your presumption of innocence and right to an attorney.
Yes, sir.
Did anybody threaten you? Anybody force you?
No, sir.
Anybody promise you?
No, sir.
Is this your free and voluntary plea?
Yes, sir.
Are you under the influence of anything? How do you plead to defective vehicle? Court accepts your plea, find be freely, voluntarily, and knowingly made. You're entitled to make a statement and welcome to. Is there anything you want to tell me?
My car accelerates really fast.
How do you like your Model
Recently.
Y?
You know, I didn't like it at first, but now that I have it has the all-wheel drive and winter tires, it does great in Summit.
Don't you like the self-drive?
Is it?
That's I've heard that
That would prevent this.
that will
problem.
take you straight to the pearly gates.
Because I have a Model Y. So you can't give me excuses about the car.
Use that.
I don't buy this. The car goes really fast. Well, it goes quick.
It goes to 60.
You use the self-drive.
0.2
Learn,
seconds.
learn to use the self-drive. It'll keep you out of trouble.
Kill you.
No, it's very conservative.
Yes, sir.
Regardless of what kind of car you own, I think that your fine will be $80, $30 court costs, $25 surcharge. That's $145. Can you pay that today? Please see my court code. I'll be self-driving home. Karen Meza de la Cruz. Good evening. Ma'am, you were summoned to court to answer allegations you were speeding in the category of 10 to 19 miles an hour over the posted limit. Do you understand that charge? The penalty for that range is a possible 4 points on your driving record and a possible fine as high as $2,650. Do you understand the possible penalty? You were provided the written advisement of legal rights. Did you get a chance to read and review your legal rights? Do you have any questions about those rights? Do you feel you understand them?
Yes.
Do you know what a trial is? I have paperwork that says instead of a trial, you wish to enter a plea to a 2-point defective vehicle. Is that correct?
Yes.
You understand by doing that, you're giving up all the rights listed on the right sheet, which means there'll be no trial, no witnesses. The prosecutor won't have to prove you guilty beyond a reasonable doubt. You're giving up your presumption of innocence and right to an attorney. Did anybody threaten you? Did anybody make promises not stated here in court? Is this your free and voluntary plea?
Yes.
Are you under the influence of anything?
No.
Now, we've covered that. How do you plead to defective vehicle?
Guilty.
Court accepts your plea, find to be freely, voluntarily, and knowingly made. You're entitled to and welcome to make a statement, but not required to. Is there anything you want to tell me?
This won't happen again.
Okay. I see you had a problem back in the early 2000s. But I trust in general you've corrected all that. Since the prosecutor didn't make you take another driving class, we're going to believe in you.
Thank you.
But I'm always nice the first time, but not the second time. Okay?
Yes.
All right. As long as we understand each other. $80 fine, $30 cost, $25 surcharge. 145. Can you pay that? Please see my court clerk. Adam Morris.
Hello.
Hello, good evening, sir. Sir, you've been charged with allegedly violating Frisco Ordinance 127 1-19 trespassing. Do you understand the charge?
I do.
It is a municipal ordinance offense. All municipal ordinance offenses are punishable by a possible fine as high as $2,650 and possibly up to 364 days in jail. Do you understand the possible penalty?
Yeah.
You were provided the written advisement of legal rights. Did you get a chance to read and review those rights? Do you have any questions about those rights? Do you feel you understand them? Do you know what a trial is? You understand you have a right to an attorney.
Yes.
Paperwork that says simply that you're going to enter into a deferred judgment agreement with the prosecutor. The way that works is you are expected to state a plea of guilty to that original charge. However, it goes into a temporary court record we call a deferred record. If you satisfy and complete the conditions, and the only conditions I'm seeing is simply not to have any other violations of the Frisco Municipal Code, that if you do that at the end of the 12-month period, the case would be dismissed and automatically sealed from public view under Colorado law. On the other hand, if at any time during that 12 months or looking back at the end of the 12 months, if we find any other violations or alleged violations of these conditions, then you'd be summoned to court for a hearing about the conditions. If it was proved you violated the terms of the agreement, then the guilty plea would enter upon the permanent record, and you would be subject to being resentenced and could face additional penalties. Do you think you understand that procedure? You understand by pleading guilty pursuant to this agreement, you are giving up all the rights listed in the right sheet, which means there will be no trial, there'll be no witnesses. The prosecutor will not have to prove you guilty beyond a reasonable doubt. You are giving up your presumption of innocence and right to an attorney.
Yes.
Did anybody threaten you?
No.
Do anything not said here?
No.
Is this your free and voluntary plea?
Yes.
Are you under the influence of anything that affects your ability to make a decision? Now we covered that. How do you plead to trespassing?
I did. I'll say I forgot. I thought it was public sidewalk again, and I went on the sidewalk. I did.
So you're pleading guilty, but deferring it, so I will accept that. Find to be freely, voluntarily, and knowingly made. Do people wish to be heard about sentence at all?
No, Your Honor. As far as I understand, it hasn't been a repeat issue with the defendant. He's trespassed once and accidentally went back onto the premises.
All right. Are you working, sir?
I was looking. I'm getting ready to move here in a few days.
Would you rather have a fine or a community service?
Fine.
Okay. This sounds pretty nominal. So a $25 fine, $25 surcharge, $30 court costs. That's $80. And you think you might have money by September?
Yeah, I can make a payment.
All right. I'll say that's the total's due by the September 17th court date, or appear here to explain to me your circumstances and what kind of extension you need, or whether you want to convert that to community service.
Okay.
Please see my court clerk for paperwork. Ronald Fleshman.
Yes, sir.
Good evening. Sir, you were alleged to have violated Frisco Ordinance 167-1-1103, impeding the flow of traffic. Do you understand the charge?
Yeah, I thought it was a distracted driving ticket, but that's what I thought it was, but,
Well, this is the.
so when I got pulled over,
Sure, let me caution, we're not, normally, let me sort of do things in order so you're fully advised of your rights. Because anything you say could be used if there's a trial, or could be used against you. And we want to make sure you understand your rights before you give up your rights unknowingly. So if we just stick to the advisement part, is first I'm required to tell you the charge. And that is the charge that I have here. And then the second thing I'm required to tell you is the possible penalty, which is 3 points on your driving record and a possible fine as high as $1,000. Do you understand the possible penalty?
Yes.
And then you were provided the written advisement of legal rights, and I have a signature on this. Did you get a chance to read and review those? Do you have any questions about your rights? Do you feel you understand them?
Yes.
And you know what a trial is?
Yeah.
And you understand you have a right to an attorney?
Yes, sir.
Okay. Now we can get to whatever you want to tell me and make choices here. I don't seem to have any paperwork from the prosecutor. Do you wish to plead not guilty and set this matter for trial? Do you wish to have a continuance for a month to go talk to an attorney or other advisor? Or how would you want to plead guilty? How would you like to handle
I
this?
got a continuance originally. He didn't offer me nothing, so I doubt that his stance is gonna change. The reason that I was supposedly impeding traffic, which I didn't, the guy was on the side of me, had almost made it through the intersection, but I started as my car stalled. I have a manual transmission. My clutch was going out, as to find out later, which I replaced, which cost me $4,000. But I think Officer Brown thought I was on my phone because he saw me looking down. So I think that's why he gave me the ticket. And I've gotten the proof of a hands-free device so that will never be an issue again. I just got the car in November. I can't do nothing I didn't understand that the clutch was going out, but I've replaced it since. And the 3-point ticket is really gonna affect me because I'm gonna lose my job because of my CDL. So I'm just, I don't know what I can do here. I thought it was a distracted driving ticket because Officer Brown seemed to think that I was on my phone, but he wasn't really listening to me. So, which is fine. That's fine. If he thought I was on my phone, that's fine. I would be the first time, and I looked it up and looked at all the effective or distracted driving infractions you could have, and I think I got that to take care of that. And
Sounds like you're asking for a continuance.
I guess I'm gonna have to plead not guilty to that then, I guess.
All
What
right.
do I need to I don't understand if I need a continuance for what. I'm not gonna get a lawyer. I'm gonna represent myself because I can't afford a lawyer. I spent $4,000 to get my clutch replaced and,
No, I appreciate that. I'm sure the prosecutor also informed you if you have a CDL, that we're unable to offer any kind of plea bargain that is done in other kinds of cases because of federal anti-masking statute.
Commercial vehicle, correct?
Yeah.
But
Yeah,
I was operating my personal vehicle.
doesn't matter if you have CDL license is the issue.
So for the distracted driving,
No, for the lack of an offer.
well, I just don't know what I could have done I started my car up back immediately, got it in gear. I don't know what more I could have done to get across the intersection in time.
Trial. So we will set this for trial on September 17th. You'll be here then?
Simmer when?
17th.
Sure.
Okay,
5:30, Your Honor.
5:30.
Your Honor, are we not having court in August?
No, we are. I'm not setting trials in August.
That's very nice of you. Thank you.
We already have one left over from last month
Yes.
that we set for August, so I'm trying to get our pacing back on track. So trying not to have multiple trial days. So, all right, let me just note the file here. Okay, my clerk will give you a written notice. If you need subpoenas, you can get those from the clerk for free, but you'd be responsible for the cost of proper service. Then I believe we have our trial. We don't have any more of the,
No, that's correct. Your Honor. Yeah.
If you all set to go on trial?
And Your Honor.
May I make a request, Your Honor, that ticket 08924 Chavarin Umberto go first due to the
Yes.
requirements for a translator. I'd like to get her out of here. Thank you.
Ms. Umberto, could you come forward? Mr. Umberto. Since this is a different court, I have to swear you in again. Please state your name for the record. Do you solemnly swear you will faithfully translate each and every word stated verbatim from English to Spanish and Spanish to English to the best of your ability under penalty of perjury? Sir, we are set for trial. Did you get our handout about your trial rights and procedures?
Be attached to this case.
Okay. I see you did. You understand that the way this goes is the prosecutor goes first because they have the burden of proof to prove you guilty beyond a reasonable doubt. And we start by asking each side if they want to make an opening statement. An opening statement is not evidence. It's basically supposed to be an outline of the case. And usually in municipal court, most people don't do that because our cases are very short compared to other kinds of cases in other courts. But you may make an opening statement, but it doesn't count as evidence. Then the prosecutor will proceed by asking the prosecutor's witnesses questions. Then you will have a chance to ask them questions. We call that cross-examination. Both you and the prosecutor must ask proper questions according to the Colorado Rules of Evidence. After the prosecutor does each of their witnesses, they will rest and you have the opportunity to present witnesses, but you're not required to. You may simply argue that the prosecutor has not proved their case. You also have the opportunity to, but are not required to testify, and you cannot be made to testify against your will and cannot be made to testify against yourself. Then once you've concluded, we have closing arguments. The prosecutor goes first. You get to make an argument, and then the prosecutor gets a chance to reply to whatever you argue. And then I will make a decision. Is that sequence of events clear to you?
No.
What's not clear?
It's clear.
Please just have a seat at the table. And again, the charge here is no proof of insurance, contrary to section 1409 of the Model Traffic Code.
Yes, sir.
Any opening statement?
Your Honor, just that the statute requires that testimony of the failure of any owner or operator of a motor vehicle or low power scooter to present immediate evidence of a complying policy or certificate of self-insurance in full force and effect as required by law, when requested to do so by a peace officer, shall constitute prima facie evidence at a trial concerning such a violation that such owner or operator violated the statute.
You have an opening statement.
Nomás cuando regresé, me dijo, entonces yo traje mi seguranza, porque la persona del carro no me dio seguranza, so tuve que traer a mí.
Okay, Your Honor, she's saying that the car that he was driving wasn't his car, and he does have insurance for his own car, but not for that other car that he was driving, but it's not, he's not the owner of that car.
Okay. If that's all, we'll go to the first witness.
People call Officer Elias Brown, Frisco PD.
You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
Please be seated over here.
Please state your first and last name for the record and spell your last name.
Elias Brown, BROWN.
Thank you, Officer Brown. Officer Brown, are you presently employed?
So, yeah.
And in what capacity?
I'm employed as a police officer for the town of Frisco Police Department.
And for how long have you been employed by the town of Frisco in that capacity?
I've been employed by the town of Frisco cumulatively for 7 years. I've been employed consecutively since September of 2024.
And do you recall if you were on duty on May 18th, 2025?
Yes.
And do you recall what shift you worked that day?
Yes, it was a graveyard shift.
And were you on duty at 11:29 p.m. that day?
Yes, I was.
And do you recall what you were doing at that time?
Yes, I was conducting routine patrol in the area of Summit Boulevard and Lusher Court.
And at that time, did you make any traffic stops?
Yes, I did.
And where did this traffic stop take place?
The traffic stop was conducted in the parking lot of the AC Hotel on Lusher Court. It was because I observed a black Hyundai Santa Fe with a defective left headlamp, as well as an expired number plate, October of 2024, which I confirmed through CCIC.
And the parking lot of the AC Hotel, is that in the town of Frisco?
Yes, it is.
And is that in the county of Summit?
Yes.
Please tell us more about this stop. You stopped the vehicle and I'm assuming approached the driver.
Yes, I did.
Please let the court know how the traffic stop happened.
A traffic stop typically happens by activating the exterior emergency lighting equipment of the patrol vehicle, prompting the traffic violator to pull over in a safe location. At that point, I make contact with the driver of the vehicle and ask for driver's license, registration, and proof of insurance.
And do you see the driver of that black Hyundai Santa Fe from May 18th at 11:29 p.m. in the courtroom today?
I do.
And could you please point a finger at him for the court?
He's to my left wearing a black t-shirt.
Please let the record reflect that the officer has identified the defendant.
The record should so reflect.
Officer Brown, when you initiated contact with the defendant, did you ask for proof of insurance?
Yes, I did.
And was the defendant able to provide proof of that insurance?
No.
And was the defendant the operator of that vehicle?
Yes.
And did the defendant say anything to you regarding, why he wasn't able to provide insurance?
Yes, he stated that the vehicle belonged to his cousin and that it was likely not insured.
Do you have anything else to tell the court about this stop? Thank you. I have no further questions.
Sir, this is your opportunity to ask the officer questions. You're shaking your head. Do you have any questions? Okay. Okay. You may step down.
Thank you, Your Honor.
No further witnesses, Your Honor.
Okay. Sir, the prosecution is rested. You have the opportunity to present evidence. Do you have any witnesses you wish to call?
Yo tengo un conductor. Ese día que él me paró, no tengo seguranza, porque la dueña del carro no tiene seguranza, pero yo ya tengo mi seguranza sobre el carro, que no es mío.
Again, he's stating that the car was in he's not the owner of that car. He's aware that the car was not insured. His own car is insured and he had insurance that day for his own car.
Sure. I appreciate that. And I hear you clearly, sir. One is what you're telling me really is testimony, not answering my question about whether you have witnesses. And that would be, do you have your cousin? Do you have anybody else? And again, you can make that argument, except the statute says the operator of a motor vehicle must produce insurance. So when you get in someone else's car, when anybody gets into anybody's else's car, you have a responsibility to ask, is there insurance? Where is the proof of insurance? So let's go back. You don't have any other witnesses, is that correct? Do you wish to testify yourself? I mean, if you want to make that statement, you can under oath, but I'm going to tell you now that the law is the operator of the motor vehicle must have insurance for the vehicle. Janice, do you have the model traffic code?
He's saying that he doesn't want to do any tests.
Okay, that's fine. Thank you. Closing statements.
I don't have one, Your Honor. Thank you.
That's fine. Sir, you may make a closing statement. Okay. All right, the appropriate statute, model traffic code section 1409 states, no owner of a motor vehicle required to be registered in the state shall operate the vehicle or permitted to be operated on the public highways of this local government when the owners fail to have a complying policy or certificate of self-insurance in full force and effect. That's section 1. As to this case, the relevant section is section 2. No person shall operate a motor vehicle on the public highways of this local government without a complying policy or certificate of self-insurance in full force and effect as required by the other sections of law. So, therefore, based on the testimony, I'm required to find you guilty under section 2. There's a minimum and maximum penalty on this. Do the people wish to make any statement?
The minimum is fine, Your Honor. It's obviously a pretty heavy minimum.
You have a right to make a statement before I impose the sentence. Is there anything else you'd like to tell me? Are you working?
Today was first day.
Okay. The legislature has required a minimum fine of $500 unless mitigation is shown. And I'm going to consider the fact that you have, I'm taking your word for it. I haven't seen the proof, but I'm taking your word for it that you have insurance on your personal vehicle, in which case I can cut that in half. It's still a substantial sum. So $250 is as low as I can make it based on what the legislature has decreed. And there are $30 court costs and $25 surcharge. That puts you back up to $305. and we can give you a payment plan if you just started to work. Janice, do you have the calendar for the October court date?
October 15th.
Will say you should pay something each month, but the total should be paid by October 15th of this year, or come to court to explain to me your circumstances and why you need an extension. Or get your cousin to send you the money. Or get your cousin to send you the money. Okay. Please see my court clerk for written notice. Okay, the second trial. Is Mr. Sexton here?
Yeah, Your Honor, I don't see Mr. Sexton here. See Alex Cabarrus. I do know that for Mr. Sexton's trial, I do have Officer Wilson here ready to testify.
Do you wish to make a record and have him testify briefly before I enter the default, or? For any reason?
We're just letting him go and you entering the default.
Right,
Yeah.
go. You're free. Court will find the defendant failed to appear. It is now 5:40. This matter was set for 5:30. And the defendant has failed to appear. Court will enter a default judgment for 4 points, $140 penalty, and costs of 30, and surcharge of 25. $195 total.
The people are ready to proceed on citation 08663 Alex Cabarrus.
Okay. Noting the paperwork on Mr. Sexton here. There we go. And Mr. Cabarrus, you ready to go, sir? Okay, just have a seat. I have your assigned trial rights and procedures. Do you have any questions about that? There.
I do not know.
Very good. Any opening statements for the people?
I would just like it be known for the court that I am going through a gender transition, so I requested that I be referred to as she, her pronouns.
All right. Anyhow, any opening statement for the people?
Yeah, Your Honor.
Any opening statement for you?
No, Your Honor.
Okay. First witness.
Your Honor, people call Officer Cole Wickland of Frisco PD.
Solemnly swear you testify truthfully that your testimony would be the truth, the whole truth, and nothing but the truth under penalty of perjury. Please be seated up here. Janice, will you give me the ordinance on camping? Go ahead.
Could you please state your first and last name for the record and spell your last name?
Cole Wickland, Wicklund.
And Officer Wickland, are you presently employed?
I am
And in what capacity?
police officer with the town of Frisco.
And for how long have you been employed for the town of Frisco?
Since April of 22.
And were you on duty on May 2nd, 2025?
I was.
And do you recall what shift you were working that day?
Swing shift.
And what is the swing shift?
It ends at 3 a.m.
Okay. And do you recall if you were working at 1:09 a.m. that day?
I was.
And do you recall what kind of things you were doing?
Just routine patrol.
And did you issue any citations, around 1:09 AM on May 2nd, 2025? And could you please describe, that citation?
I believe we were heading back to the police department, going down Main Street, and we observed an individual camping. We made contact, and issued a citation for camping.
And where, did you make contact exactly?
Oh, my apologies. Historic park under the gazebo.
And is Historic Park in the town of Frisco?
It is.
And is it in the county of Summit?
It is.
And is it a park in which the town is the owner, operator, or both?
It is.
And could you please describe kind of what you observed as you issued the citation?
The individual was sleeping in a sleeping bag. Typical camping gear. It's all on body cam, so we can watch that if you want. Contacted, turned out to be Kayla. We advised Kayla that she was not allowed to be camping on public property, and that was pretty much it.
And were there any signs that permitted camping or staying overnight in the park?
I can't remember.
Are you aware of any area in the town in which you're permitted to camp or stay overnight? Is there anything else you'd like to tell us? Oh, let me ask you this. The person that you contacted, do you see them today in the courtroom?
I do.
Could you please identify them?
Yeah.
Please let the record reflect that Officer Wickland identified the defendant.
Any objection?
I definitely wasn't in a sleeping bag, so I didn't honestly.
The issue is whether or not he's properly identified you.
No.
Record shall so note.
Is there anything else you'd like to tell the court today?
No, sir.
We have no further questions, Your Honor.
Cross-examination. This is your turn to ask the officer questions if you wish.
My only concern is I'm just questioning why it was necessary. There are no signs posted that say yes or no, whether you can or cannot sleep overnight in the park. Like I just stated, I was not in a sleeping bag. I did not own a sleeping bag.
This is your option to ask the officer questions. So please, if you have questions, if you want to testify, you can do that later. Or if you want to ask him points, but you need to put it in the form of a question.
Okay, I didn't realize this was Jeff. No, Your Honor.
Okay. No redirect. Thank you. Okay, so that's fine. I assume the people rest.
Yes, Your Honor. Thank you.
All right. Before proceeding, let me read the ordinance. 130-11 camping. It is unlawful for any person to camp or stay overnight in any town park, open space property, or recreation area, except in an area designated for such use. That's the ordinance. Now, at this point, sir, do you have any witnesses you wish to call?
I do not.
Do you wish to testify? Before you do, I have to give you what's called a Curtis warning, named after the People versus Curtis case. You have the absolute right to remain silent. You may simply argue the people have not proved their case beyond a reasonable doubt. You also have the absolute right to testify if you choose to. That no one can make you testify, and no one can make you testify against yourself. If you choose to testify, you are subject to treatment like any other witness, in that you are subject to cross-examination. We don't make you ask yourself questions, but you're sworn under oath to tell the truth. You may make a statement, and then you are subject to cross-examination. The next point is, once you waive the right against self-incrimination, that is, once you waive your right to remain silent, you cannot re-invoke it. You must answer all questions that are proper under the rules of evidence. So the prosecutor asks you the first 3 questions, and they don't bother you, but you don't like the 4th question, you can't then say, well, I'm re-invoking my right to remain silent. As long as it's proper under the rules of evidence, you would be required to answer those kind of questions. You also are subject to what's called impeachment under the rules of evidence. That is, if there are prior bad acts or prior convictions, that can be inquired into if you choose to testify. Now that I've completed the warning, then I get to ask you, do you wish to testify or not testify? Yes, you do. Okay, very good. All right. Shall we switch seats around here?
Yes.
Officer, you may step down. Please come forward. Please raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Please make your statement.
The night in question, I had recently been kicked out of my dad's house where I was living. I've been largely nomadic for the last several years, just going through a lot of really difficult life situations. And I had no camping gear. I understand that you're not supposed to camp in town. However, I did not have a sleeping bag because I did not have any camping equipment that night. My camping equipment was last set up down in Buena Vista this winter. It got stolen. I had no tent, no sleeping bag. I was scared, exhausted, didn't know what else to do. It was the night before. It rained all night. I didn't want to be sleeping out in the woods unsheltered. So I found the place that I thought was safest for me and everyone else in town. I was not doing anything to harm anybody. I was asleep when the officers contacted me. And basically, as an autistic person, if something doesn't make sense, to me, I just don't get it. Like, I understand that laws are created to create order, and keep people from harming other individuals. However, nothing I was doing was a threat to anybody. I am a Summit County native. I've lived in Frisco for over 20 years, and the plaque in the lobby, I don't remember the exact wording, basically says that their job is to serve the community and the best interests of the community. And as a member of this community, I feel like they did the exact opposite of that. There was no reason to confront me. And I didn't have any other options. I ended up being marched, like, basically I felt like I was being confronted by a bunch of riot guards. I got stuff, packed it up, started walking down the street, and they kept just marching me farther and farther. I had no energy. I had like 50 pounds worth of stuff on my back because I grabbed all of the stuff I thought I would need from my house before I left. I would have gone all the way out to the forest, but I did not have the physical energy or the mental willpower to walk another 5 blocks with all of my stuff. And I just don't understand why. Like, I have every reason to not trust this police department. I have been lied to repeatedly. One of the statements your officers made just now under oath was a lie. I did not have a sleeping bag. I was in the park to begin with. And I am more than willing to own up and take responsibility for my actions and suffer whatever consequences may come of it. But I'm mostly pled not guilty to have the officers uphold their end of the bargain and prove me guilty in a court of law. I'm not I'm not worried about the penalty. I understand it's going to be pretty minimal, but I don't know. I've seen this community devolve into a quasi-authoritarian state. This is my home. I don't have anywhere else to go. And I want to see change happen. I don't believe that it is necessary to ticket an individual, treat them like a criminal for simply trying to survive. I was doing the best that I could given the circumstances. I had just, right before this whole situation happened, I had a plan laid out for months with a friend to move down with her in Canyon City. That fell through. And then I got kicked out of my dad's house because we just got into a bunch of arguments because I was going through a bunch of stuff at the time. And basically I was just scared. Like they did the exact opposite of what they're supposed to be doing, which is serving and protecting this community. And I feel like they failed on both of those accounts. And I just want to understand why it was even necessary. I was dead asleep when they found me. I was no threat to anybody. Nobody had called the officers on me to say that somebody was sleeping in the park. If they had just let me sleep, nothing, like there would have been no harm. My plan was not to continue living in the park. It was merely the safest option because I didn't want to go lay down in the woods somewhere with no tent, no sleeping bag. I was fortunate enough several days later to acquire some camping equipment from a friend who had an extra tent. And it's, I don't get it. And I have been repeatedly lied to by this police department over the last year. Yeah. And I see town officials, both law enforcement and town employees, breaking the law whenever they feel it necessary. There's no alcohol allowed in the park, yet every Thursday we set up a beer tent because the town decides that, okay, we can break the law because we want to. I see town cars parked on the sidewalk in the middle of the day. I see town cars parked across multiple parking spots when they don't need to be. It's just this insane level of hypocrisy that has become normalized in our culture. And I want to do whatever I can to change things. Because I've been a longtime member of this community. I walk around all day. I don't have a car. I pick up trash when I see it. Not all of it because it's not my job, but I care about this community. And yeah, I ended up sleeping one block behind, literally on the side of the road, instead of having a shelter. And I had talked to one of the officers involved after the fact, and he claims that they were aware that I was sleeping there, but they didn't do anything about it. It just the whole situation, like under other circumstances, I would have had no problem just pleading guilty at the arraignment. But because of the circumstances, I felt that what I did was the safest for everybody involved. I have since gotten over my mental health issues. I started working this week. And I don't know. I want to make sure that if officers are going to write out tickets willy-nilly, that they're prepared to go to court over every single ticket that they write. I don't think I have anything else to say.
Cross-examination.
No, Your Honor.
Okay, you may step down. And you have no other witnesses? No, Your Honor. Any rebuttal?
No, Your Honor. And I have no closing.
Okay, I didn't know if you wanted to show me the video or not. Is all I was.
Oh, no.
Okay, fine. No closing. Do you have a closing statement?
No, Your Honor.
Okay. I've read the ordinance. I read it out loud to you earlier. Unfortunately, the ordinance is fortunately clear. There's not an exception for I'm too tired to get to the campground. I also find the statement that you had 50 pounds of stuff inconsistent with the claim you weren't camping. This isn't a reply. This is just my findings. So this is not a discussion. Based upon which is essentially uncontroverted testimony, I find that the defendant was in the park on May 2nd at 1:09 a.m. Sleeping in the park in a manner that constituted camping as defined by the statute, and therefore find you guilty. Any requests by the people?
Do you mind if I get a minute with?
You can have all the time you want.
Thank you, Your Honor. In terms of fine, I don't have a recommendation. I'd ask that you consider an order barring the defendant from town parks for a year.
Sir, this is your opportunity to weigh in. Ma'am, it is your opportunity to weigh in.
As far as the 50 pounds goes, that's everything that I needed. I'm trying to be a professional artist, so I had all my art supplies, I had food, I had extra clothing. I did not have a tent or a sleeping bag. And I just don't understand what, like, if I'm not harming anybody, what does it matter? I think being barred from parks for a year is extremely excessive. I have not done anything. I've not slept in a park since. That was the last night that I did. Like I said, I've been a member of this community for my entire life. And also when I was here for my arraignment, one of the gentlemen ahead of me was here for basically the same thing, and you gave him just 8 hours of community service. And I don't think it's fair to give me anything more than that for exercising my right to have the officers prove me guilty.
And my only question was, are you working?
Yes, I just started working at the Frisco Lodge this weekend.
Anything else? Okay. The court will fine the defendant $160. And actually, I'll make it so the total comes out different. I will fine the defendant $105 and $25 surcharge required by town council, $30 court cost for a total of $160. Or you may either pay that or you may do 8 hours of community service. Court will impose a condition that you are not to be in any town park after 7 p.m. And before 7 a.m. for the rest of the calendar year.
Thank you, Your Honor.
You may have day use as any other citizen, but make it clear, 7 PM, you're out of the parks till the following morning. Heaton Bay Campground is close.
I have a place to live now.
All right, very good. I'm glad things are improving for you. Will you be doing the 8 hours of community service?
Yes.
All right, deadline to complete that is by September 17th court date, or appear back here to explain why you didn't get it done. Any questions? All right, that will conclude the matter. Oh, I have to say at the trial, you have the right to appeal my decision today to the District and Appellate Courts of Colorado within 35 days of my entering the order of your sentence, according to the Colorado Rules of Appellate Procedure. Thank you. Okay. Clear. I understand the other trial we called and defaulted has appeared. And the officer's already gone.
No, he's
Oh,
right there.
all right,
I'm
Now we-
presuming you will want to proceed.
we'll proceed.
Do you mind if I go to the bathroom really quick?
I do not mind at all, and it doesn't have to be quick.
We are ready to proceed.
Back on record. Mr. Sexton, please come forward. Sir, you were late, so I entered a default judgment, so I assume you want me to set that aside.
I was informed that the trial was at 6 PM, Your Honor. I was in here at 6 PM.
No, it's 10 after. I thought you just got here.
Oh, no, No, I was waiting throughout the proceedings of the last hearing.
Okay. Court will set aside. You received your trial rights and procedures. Any questions?
No, Your Honor.
All right, please have a seat at the table. Any opening statement?
No, Your Honor.
Any opening statement for the defense?
No, Your Honor.
First witness, prosecution.
Call Officer Caleb Wilson to the stand.
Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury? Please be seated over here at the table. Please proceed.
Officer Wilson, could you please state your first and last name for the record?
Yes, Caleb Wilson,
And could you spell your last name, please?
Wilson.
And how are you presently employed?
Be a police officer with the town of Frisco
And how long have you been a police officer for the town of Frisco?
since December of 2023.
And were you on duty on April 12th, 2025? And do you recall which shift you worked that day?
I believe it was a flex shift.
And what kind of shift? What does that mean?
It's 11 a.m. to 9 p.m.
And so you were on duty at 3:57 p.m. that day. And do you remember what sort of duties you were performing at that time?
I was stationary at Summit Boulevard at Main Street, monitoring traffic speeds.
And have you received any training in the estimation of vehicular speed? Could you describe that for the court?
Yeah, it's LiDAR training consists of a class through the academy, basically telling you the speed of people who are trying to think of how to. Sorry, I'm not all there right now. As far as the certification goes, it's just telling me that I'm certified in estimating speeds of people who are driving.
And could you go more into what estimating speeds means?
Yeah, visual speed estimate. If I'm sitting in a posted 35-mile-per-hour zone, I can visually estimate if someone is exceeding that speed limit by usually 5 miles per hour increments.
Like a plus or minus 5
Yeah.
miles. So on April 12th, 2025 at 3:57 p.m., you are stationary at the corner of Summit and Main. Do you recall what you observed?
Yes, sir. I observed a black Chevy pickup truck traveling at a VSE visual speed estimate of 55 miles per hour in a post 35-mile-per-hour zone.
And where are the postings for that?
There are 4 postings from I-70 heading southbound on Summit Boulevard. One is going to be after the Summit and Lusher intersection. One will be after Summit and 10-mile intersection. One will be after Summit and Hahn intersection. Then one will be right before Summit and Main, where I was sitting.
And for the black pickup truck that you described, did you initiate a traffic stop?
I did.
And where did that traffic stop take place?
It was.
Yes, you may. So is there something that would help you refresh your recollection here?
Yes, my report.
Okay. Showing you a copy of the report. Actually, second sheet, he does not. May I approach?
The record should reflect you've shown it to the defendant.
Yes, thank you, sorry, Your Honor. Could you please read that silently and then let me know when your recollection is refreshed so that I may retrieve the document? Now, Officer Wilson, do you recall where the traffic stop took place?
Yes, Summit and Granite.
And is that in the town of Frisco?
Yes.
And is it in the county of Summit?
Yes.
And prior to making the traffic stop, you stated that you used a visual speed estimate.
Yes.
Did you do anything else to corroborate this speed estimate?
My visual speed estimate was confirmed by a LiDAR device.
And what's a LiDAR device?
It's a laser instrument that projects a laser onto a vehicle, sending a laser back and telling me the speed that that vehicle is traveling at.
And how do you know the LiDAR is working properly?
Before my shift, I do a calibration test. On the west side of the police department, we have a stationary position that we stand at, and we point it at a handicap sign, which is approximately 60 or 63 feet. And then I pan it over to the fence, which is another 68 feet. I usually point it at the tower in the west parking lot, which is 70 feet from that standing position.
And did you do those tests prior to going out on your shift that day?
Yes, I did.
And do you know if the LiDAR receives any certifications?
It does.
And where do you get those certificates from?
It's with the state of Colorado.
Your Honor, I have what's been marked. Unfortunately, I could not edit the certificate to put an exhibit. It says petitioner's exhibit and not people's exhibit. I'm sharing a copy with the defendant. May I approach?
Thank you, sir.
I too have run out of stickers of the right kind at the right time.
Yeah. It wasn't great. Officer Wilson, do you recognize that document? And how do you recognize it?
This is a certification that we have on file. Our LiDAR's down to the Colorado Department of Agriculture to get certified.
And getting these certificates and keeping them on file, is that something that happens in the ordinary course of the police department?
Yes.
And does the certificate look like a true and accurate copy as you last saw it on file?
Yes.
And has it been altered in any way apart from the little sticker that I appended at the bottom? Serial number that's on that certificate match the device that you were using that day?
Yes.
And is the calibration record effective on that April 12th, 2025 date?
Yes.
Your Honor, I ask that the certificate marked as Petitioner's Exhibit 1, People's Exhibit 1 be admitted in evidence.
Any objection?
No.
All right, exhibit 1 admitted.
So, Officer Wilson, based on your training experience, was your LiDAR device operating properly on April 12th, 2025?
Yes, it was.
Your Honor, I would ask at this time that the court take judicial notice. And how do you know that it was confirmed?
I usually have a stationary object that the vehicle is approaching, and however fast that vehicle is approaching from like a 35 mile per hour speed, if any vehicle is approaching that object at a speed any higher, I can usually estimate their speed by increments of 5 miles per hour.
Yeah, and then how do you know that the device is clocking the speed properly?
Oh, it's a red dot sight that I put onto the vehicle itself.
And the red dot sight was on this black pickup truck.
Yes, sir.
And was it confirmed by any, are there any confirmations from the device that you've received a reading?
Sorry, can you repeat?
Does the device confirm that it's giving you a reading that you know?
Yes. Yes.
And how does it do that?
It makes an audible sound, basically telling you that it's successfully reading the speed of that vehicle.
And at that point, once you've gotten what was the speed reading, I should ask?
That was 53 miles per hour.
And at that point, once you've received your reading, what do you do?
I pull out and I initiate a traffic stop on that defendant's vehicle.
And at any point, did you lose sight of the vehicle that you clocked? And was the vehicle that you pulled over the vehicle that you visually observed and then subsequently used the LiDAR on?
Yes.
And did you pull over that vehicle?
Yes.
And did you come into contact with the driver of that vehicle? Yes. And do you see the driver of the vehicle whose speed you detected here in the courtroom today?
I do.
And could you please point that person out for the
It's
court?
Individual to my left with the white button down.
Please let the record reflect that Officer Wilson has identified the defendant.
Any objection?
So identified.
Did the defendant make any statements to you during the traffic stop?
He stated that he was on his way home.
Okay. Is there anything else that you'd like the court to know today? I have no further questions, Your Honor.
Cross-examination.
Are you all familiar with the manual on uniform traffic control devices?
You get to address the
Just,
witness.
are you familiar with the manual on uniform traffic control devices?
No, I'm not.
Okay.
Sir, excuse me, are you able to come to the podium so
Yes,
you're recorded? Thank you.
All right, so yeah, the manual on uniform traffic control devices it's a handbook which outlines the federal law governing all traffic control devices. It states that non-compliance with the MUTCD ultimately can result in the loss of federal aids funds as well as in a significant increase in tort liability. It's stated in the MUTCD and also stated by the ITE, which is the Institute of Technical Engineers, sorry. In order for a speed limit to be enforced, a speed study must occur. And that study must take place within every 5 years. I've received a copy of the speed survey for that particular stretch of road in which I was pulled over on LiDAR on. I have
Your Honor,
copies of that speed
should I
survey
just
here.
interrupt the, if,
Yeah, you're supposed to be asking this witness questions
I'm just
and you're testifying.
Oh, okay. Okay, great.
I assume that was your objection.
yes, thank you. Sweet.
Then let's give me 1 second here. Sorry, this is my first time in court. I've
No
not
worries.
done this before and new to it. Great. So Officer Wilson, how did you determine that the laser you used was accurate for that day specifically?
Making a calibration before my shift.
Okay, and do you have any written evidence of that calibration?
No, but it's visual that I know that my LiDAR is working.
Okay. Sweet. And then, so is the self-check of the unit an electronics check?
Yes.
Okay. And besides the self-check, what other test on the laser LiDAR device did you do?
Like I told him, it was a calibration. We have a standard point on where we stand at and point our laser at a fixed object that we have a set distance of. All three of those objects that I pointed at was the set distance that I have had that laser calibrated at.
Okay. So were you able to see the beam of light from your laser LiDAR with your eyes?
No, I was not.
And then without checking the unit against a car in a test, where there is absolute confirmation of how fast that car was going, can you, with legal certainty, based on your engineering knowledge of the laser or LiDAR, state that it worked that day per engineering specifications?
Due to my calibration, yes, I can say it was working.
Okay. If you could detail for the court your engineering qualifications. Do you have an engineering degree specializing in laser spectrometry, or have you done scientific research into the specific unit?
I took a class during the police academy that made me
Okay.
LiDAR radar certified.
Great. And did you, when you LiDAR'd my car, did you do it through the glass of your car?
No, I did not. My window was open.
Great. Did you know that light is bent by the moisture in the air?
No, I did not.
Okay. What was the moisture level in the air at the time that you used your laser LiDAR to write my summons?
Believe it was dry.
Okay, sweet. So was there any compensation made for the moisture content?
I don't understand your questioning.
Because there would have been at least some moisture content in the air. It's impossible for it to be completely dry. There's at least a little bit of humidity in the air at all times.
I think that question lacks foundation. You have to provide evidence.
Okay. Cool. All right. Well, I have no further questioning at this time.
Okay. Any redirect?
No, Your Honor.
Okay. May the witness step down.
Yeah, I have no further witnesses. Thank you.
People are resting. Mr. Sexton, do you have any witnesses you wish to call?
No, Your Honor.
Before you make the decision about whether you testify, I have to give you what's called the Curtis warning. So you may have heard me do it in the last case. I don't know what time you got here. You understand under People versus Curtis that court is required to advise the defendant that you have an absolute right to not testify. You also have an absolute right to testify. That if you choose to not testify, it does not imply wrongdoing on your part. It is just the lack of evidence. The court can only consider evidence, and evidence only comes from witnesses, their testimony under oath and exhibits. If you choose to not testify, you may simply argue the people have not proved their case, and may argue about the flaws in the people's case, that they have not proven their case beyond a reasonable doubt to a sufficient degree to overcome your presumption of innocence. However, you may also testify if you choose to. If you choose to testify, you would be sworn under oath, treated like any other witness, except that we don't make you ask yourself questions. That would be rather silly. We swear you under oath to tell the truth under penalty of perjury. You are then able to make a statement, but then you are subject to cross-examination like any other witness from the prosecutor. You must answer all questions that are proper under the Colorado rules of evidence. You cannot re-invoke the right to remain silent once you've waived it. So for example, if the first three questions are innocuous, like how old are you, where do you live, whatever, but you don't like the fourth question, you can't, I want to remain silent. You cannot do that. If it's proper under the rules of evidence, you must answer. If you refuse to do so at that time, you could face contempt. You get asked cross-examination questions that also may involve impeachment, if this might be relevant, if there are prior convictions or prior bad acts, you can be asked about those. I think that constitutes all of the Curtis warning. And now I get to ask you, knowing all that, do you wish to testify or not testify?
I do wish to testify, Your Honor.
There we go. Please come over to the witness chair.
1 second here.
It'll also give you more room to spread out whatever papers you have. Please raise your right hand. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do, Your Honor.
Please make your statement.
First, may I approach with evidence of my testimony?
That's not customarily how it goes. I mean, the methodology is usually you have to testify, lay a foundation for an exhibit, and then offer that exhibit, and whether or not the prosecutor objects, and then the court gets to see things at that point.
Okay. Sounds good. Great. Okay, great. So, my first point here is based on the manual on uniform traffic control devices. So a lot of the obvious question is who uses the MUTCD and how. So in the public sector, the most obvious MUTCD users are the state and local transportation professionals and traffic engineers who design our roads and locate the traffic control devices that help drivers navigate them safely. Another part of that is that the MUTCD is the law governing all traffic control devices. Non-compliance with the MUTCD ultimately can result in the loss of federal aid funds, as well as in a significant increase in tort liability. I have an article here which was submitted to or published by the National Motorists Association and used in research for Transportation Research Board. It states that ITE guidelines, or the Institute of Technical Engineers, their guidelines state that highways should have safety reviews at least once every 5 years, and this includes an engineering
Your Honor,
study.
I think I'd just object on the fact that he's reading an article and as hearsay and not an actual statute or law.
Any response to that?
The fact that it was used for research on traffic control.
Still hearsay.
Okay, great. Well, it's also stated in the manual on uniform traffic control devices, which anyways, I have copies of the speed survey for the particular stretch of road that I was pulled over on. And that speed survey dates back to October 7th, 2009, which is about 16 years ago, just about, which is far outside of that 5-year allotment of time that traffic engineering surveys should be done.
And just to be clear.
Yep.
Your article says it should be done every 5 years, but there's no law saying it has to be done every.
It's stated in the manual on traffic control, manual on uniform traffic control devices, which is federal law.
I guess we'll get to that, whether it is or is not.
Great.
Continue.
Okay. And you can also refer to 23 CFR 655.603.
Repeat that, please.
23 CFR 655.603, which adopts the manual on uniform traffic control devices as the national standard for all traffic control devices installed on any street, highway, or bicycle trail open to the public travel. And that confirms the statement on every 5 years that speed survey needs to be conducted in order for the speed limit to be enforceable.
Your Honor, can the defendant point us to the part of the regulation that says what he's claiming?
I don't have it in front of me at the moment, so not currently. Yeah, I would like to motion for a dismissal on those grounds that the speed survey is outdated.
Your Honor, I haven't seen a copy of this speed survey, and as far as I'm concerned,
Your
that's
Honor.
admitted evidence.
One thing at a time. Yes, first of all, you've not offered anything as an exhibit. All you've done is read things. They need to be labeled as exhibits. They need to be shown to the prosecutor. And then we have to have a ruling on whether they're admitted or not. So let's back up.
Yeah.
You mentioned an article. Are you offering that as an exhibit?
I do have that as an exhibit, Your Honor.
So I'm gonna call that defense one. Or do you want, should I use letters? I guess you use numbers.
I use numbers.
Defense A. And you made a hearsay objection. I'm reading from it. Do you have an objection to the whole article?
I don't know how it's able to be authenticated as a true and accurate copy of the article.
Okay. Any response?
I printed it directly out from that web page which the article was on.
It's still hearsay, even if it's an article. So I'm not going to admit A. We will take a copy of it for the record, for the court record, though, so that we have that for any appeal record.
Okay, where should I bring that?
You should write up. First of all, have you given, how many copies do you have?
I have 3.
All right, Vic, give one to the prosecutor and you can give one to the court clerk. Just make sure that it's labeled defense A.
Okay.
Or, yeah, you can put a little triangle in A.
Have a pen with me, so need a pen to do that.
And then you've mentioned the manual. Do you have an excerpt from this manual?
The one that I stated earlier, give me 1 second, sorry, Your Honor.
You need a pen?
Oh, actually, that will for this
What have
one
we
as
got
well.
now? Oh, this is A. All right. Yeah, there's extra pen. I have my own pen in that one.
Then I'm assuming the speed survey copies would be exhibit B.
That's up to you as to what's in what order. I'm trying to be clear what it is you're trying to offer.
Great.
All
We'll
right,
go with
so
that.
defense B is the survey. Was this something provided in discovery from official town records or what is this?
The article?
No, the speed survey.
Yeah, this is from the Department of Transportation. It's a public records request.
Okay. Do you have like a letter from CDOT?
I have an email that confirms that it was a Cora request.
Do you have a copy of that?
Do not have a copy of that, unfortunately.
Any position?
I can't say, Your Honor, without seeing the survey first, but I mean, if
Yeah.
it's got
Do you have a copy that you provided to the prosecutor?
Yes, no, I haven't provided it yet, but okay, great.
Okay, what's your position on the survey?
Your Honor, I don't know how we could authenticate this document, and I'm thinking it's
I'm going to admit Exhibit B. All right, what other documents are you offering?
I have documents that are essentially explaining the manual on uniform traffic control devices, and who uses it and how it's applicable to this case. I can present those as well.
Again, I'm not going to admit them. If you got something that's commenting about how it's used, that's hearsay.
Yep.
And
Well, then, no, I do not.
if you want that as part of the record, you may have it marked, and I will then officially deny Exhibit C.
Sorry.
You don't need.
I do not have any more to present, Your Honor.
Okay. And did you have an excerpt from the manual itself? I was unclear about that.
I don't have a copy of it, Your Honor.
Okay. All right. I just want to make sure we have everything you wanted to offer. Cross-examination.
I don't think I have any, Your Honor.
Good. That concludes your case, unless you have other witnesses or others.
That's it.
All right, you may return to the council table. All right, closings.
People presented competent evidence that the device in question was working on the day in question, at the time in question, and for the same traffic stop. Defense was not able to provide competent evidence to overcome the fact that the device was working. Despite the claims from the defense, I see no actual legal citation that states that the town is in violation of the manual of uniform traffic control devices. And that's really our position.
Okay, sir, you're closing.
Yeah, I'm not sure how we're able to prove beyond a reasonable doubt that that actual piece of equipment was calibrated on that day without any written evidence of that. It's simply hearsay of, yeah, I did the calibration and I visually saw these things. There's no actual written evidence of that calibration taking place.
Anything else?
That's it.
Okay. The court finds on April 12th of 2025, Officer Cale Wilson was on duty within the town of Frisco, County of Summit, state of Colorado, within the jurisdiction of this court, stationed at Summit Boulevard and Main Street monitoring traffic at 3:57 p.m., where he observed a black Chevy pickup truck that he used his training for visual speed estimate, VSE, as being going 55 miles an hour. The officer testified both as to his visual estimating skills as well as his training in LiDAR. The officer, or the unrefuted testimony is there are 4 signs from I-70 going south towards Breckenridge, along highway, it's State Highway 9, also known as Summit Boulevard. At the intersections, it passes Lusher Court 10 Mile Drive, Pond Drive, and before Main Street. That the officer indicated in accordance with the protocol for testing the LiDAR, that it worked properly at the station, looking at the stationary objects around the police department for 53 feet, 68 feet for the fence and 70 feet for the tower by the parking lot. The people presented and was admitted without objection the LiDAR certification indicating this was a working unit, and the officer testified that it pass all tests, including the self-test that day. I appreciate the defense not a lawyer, but that's not hearsay. That's direct testimony, and that is proper authentication that the unit was working that day. The tests were conducted. There is not a requirement of some kind of written record or visual looking over the officer's shoulder. There's no question. The court does not find any evidence refuting the officer's testimony that he conducted the tests and that the unit passed the test. And I find the unit was working that day. The court also takes, as noted without objection, took judicial notice of the principles underlying the LiDAR. And court can provide a case citation later. It escapes me for the moment, the name of the case. But Colorado's long recognized both radar and once LiDAR came along, LiDAR are scientifically accepted. Officer was asked various questions about the LiDAR. And again, some of it was repeat of his testimony that he did the checks that day, also the self-checked work. He was asked whether he saw the red light. You can't see a laser red light going forward. I don't find that to have impeached the workings of the LiDAR unit at all. He did have the window open. The court does not find any factual basis other than pure speculation that there might have been some moisture in the air that somehow altered the LiDAR. In general, it has to be a heavy downpour from what the court has had in prior testimony in prior cases. But regardless, I can't consider the prior cases. What I can consider in this case is no impeaching evidence. There was no moisture level introduced by the defendant. There was no expert testimony indicating that the moisture level that existed on that day would have affected the LiDAR on that day. So I don't find any impeaching evidence as to the LiDAR. As to the manual on uniform traffic control devices, the court was, due to the miracles of the internet, able to pull up some actual parts of the regulation. The court notes, as I understand, 23 CFR 655.603, looking at what I'm seeing here, it states in subpart B1 that while these are federal standards, this is for federal highways, and it encourages states to adopt it, but it doesn't require states to adopt it. The penalties are, as the defendant said, they have to do with state highway funds and they have to do with tort liability, but they do not impede or impair traffic regulations of speed limits put up. There's nothing in this CFR that would authorize the abrogation. Under your theory, I suspect most of the highways in the state have not been resurveyed every 5 years. And in fact, most of the highways in the country have not been recertified in 5 years. But I find that irrelevant because this is a state highway. These are federal regulations, and it says you have to have the state adopt standards, and you've not produced any proof of state standards that the town of Frisco has violated. And again, it being a state highway, it is a state responsibility of the Colorado Department of Transportation. And you have no evidence from anybody in CDOT that their highway in our town violates their standards. So I don't find any impeachment of the speed limit that was established, that this was a 35-mile-an-hour zone. And the ticket notes that you were going 53 at 532 feet, which also gives the court sufficient specificity that the LiDAR was working properly at that time. And accordingly, I'm going to find you guilty of speeding 10 to 19 miles an hour over the posted limit. I appreciate your research, but I don't think it applies. Any statements by the people? Driving record in this case?
No, Your Honor. Thank you.
Okay, I don't see any prior bad driving record. Are you working?
Yes, sir, Your Honor. I work at the Dillon Marina.
Okay. I just will impose the penalty on the schedule, though there are court costs and surcharge applied to that. That is $140, $25 surcharge imposed by council. I have no control over $30 court costs. It takes you up to $195. Can you pay that today, or do you need a payment plan? Okay. That'll be the judgment of the court. If you wish to appeal my decision, you have 35 days from today to file with the district and appellate courts of the state of Colorado in accordance with the Colorado Rules of Appellate Procedure.
Okay, thank you, Your Honor.
Uh-huh. We are adjourned. The clerk will maintain the record of this for at least 35 days.
Also, just want to thank everyone for your time today. Thank you guys. Appreciate it. Yeah. you too.
Unless you want to hold on to it, something to remember, Brad.
Yeah.
Thank you for coming out.
Of course.
Thanks for waiting around.
So. All good.
It's such a marvelous thing. I can pull up law on my phone in the middle of a trial. Keep the notes too.
Yeah.
Well, you have my notes. Notes are not part of the record. Actually, you can not, you can also destroy mine.
No, I didn't drive home to that. That's fine. That's my next fun time.
Well, and you know what illusion I was in? I was thinking I was going to sneak back out of my boat for an evening sail, but I think I'm pressing.
Courtney said you're a race car driver?
I was a test driver for Ford.
Oh, wow.
There's a difference.
Okay.
Thank you, sir.